Good morning.
Morning, Judge.
Morning.
Morning.
I'm going to take up a couple of the quicker matters first, and then I'll come back to the lengthier stuff. On 20 DCV 274111, like I have a motion to withdraw filed by Ms. Prophet's office.
Yes, Your Honor.
And how did you send notice to your client on this case?
We've sent it via both regular mail and certified mail, but we don't have the green card back yet.
That's okay. And are there any pending settings on this case?
Not that I know of.
Can you send me that order? The clerk sending me your order. The motion to withdraw is granted, and the court is signing your order. Thank you for appearing this morning.
Thank you.
Have a good day.
You too.
That order's been signed. That matter's completed. Do we have everybody here on? Just 1 second.
No, we don't have my client, Your Honor. Are you saying 20?
Yeah, we got, people are just now coming in. Mr. Lockings is coming in. So are we missing anybody on the Leggett case? Mr. Burleson, we're missing your.
Sure. Due to a mistake, clerical error of my office, we put one digit wrong on the zip code. I didn't get notice till 5 minutes or 10 minutes before this meeting. I called my client and he had something he just could not, he had to go to, something he had to do. So I got this day next week available if we can do this next week.
Well, it's Mr. Arrington's motion, and
Judge,
he has proper notice. I mean, I'm going to let y'all, I can put y'all in a room if the lawyers want to talk about it, but here's the thing. I mean, the court ordered an amicus attorney on the case, and the court ordered the parties to pay that fee, and that needs to be done. It needs to be figured out somewhere or another to get this case moving, because the court's going to get the lawyers paid. And I do that on every case, whether it's an amicus, it's wife's lawyer, husband's lawyer, mom's lawyer, dad's lawyer. If it's a reasonable request for attorney's fees, the court's going to get the lawyers paid, because I don't expect lawyers to work for free, especially amicus lawyers, because the statute specifically says if you're requesting an amicus, that there needs to be funds there to pay for the amicus. So before I will even appoint an amicus, I'm asking the lawyers or the parties to confirm to me that there's enough money to pay for an amicus to get on board. Because the last thing I want to do as a judge is appoint some lawyer as an attorney and then not get paid. I mean, that's doing a disservice to the lawyer, and it's just not a healthy situation. So that's the court's view on it. That's Judge Heppard's view on it as well. We want to get lawyers paid across the board because we don't expect people to work for free. So that being said, I'm not sure what the issue is in this case, but it's just going to get worse the more we're coming down here to talk about it. So because we're running up 3 lawyers' fees to have a hearing on getting a child lawyer paid. So it's not good use of the party's time, the court's time, or the party's money, in my opinion. So Mr. Burleson, I know it's not your issue. I mean, it's not your fault. You got a client that evidently is not paying the amicus, but do you have any reason as to why we're having to have this hearing?
Well, I told the amicus attorney back in March that my client couldn't pay, and that's why we filed a motion the affidavit of indigency, and we filed a motion along with it. And he said he didn't act it at the time, no big deal. And then all of a sudden he files this motion for enforcement. He's
Well,
known about.
I'm sorry to interrupt you, Mr. Burleson, but Judge Katrina Levert from the County Attorney's Office, we are contesting the indigency of Mr. Leggett. He did file a notice of indigency for purposes of paying amicus attorney, and he also filed a statement of inability to pay court costs. We're contesting that because what he failed to do is provide attachments or provide proof that he cannot pay. And the clerks think is that he has an attorney, which I'm assuming he's paying for. And this order was signed in February of this year. If he would have just paid $240 a month, that fee could have been paid. So we're asking for a judgment in that amount. And we did attempt to serve Mr. Burleson, but again, on his notice of indigency, the zip code was wrong. So we did not get to serve him for that reason. Thank you, Judge.
All right, Mr. Arrington, it's your motion. What do you want to do? We've got evidently a respondent that's not present and is available next week. But what's your attitude on going forward today or resetting?
Well, Judge, Mr. Locking's client has paid the court-ordered $1,200 fee, and I'd really like to equalize the case and have Mr. Burleson's client pay the $1,200 fee. Quite frankly, Judge, I've already done enough work to essentially eat up the entire $2,400. If they had both paid, I would have already used up that entire $2,400 as of today. So I'd like to go forward on my motion, but if you want to send us to another room for us to chat about that, I'm certainly open to that idea.
Well, can I say something, Your Honor?
You may.
The judge at the last hearing suggested a motion for costs that Mr. Arrington should file. I told him that the last time I talked with him, which was about a month ago. And he insisted he was going to file a motion for enforcement. So seems to me he's not being reasonable.
Judge,
I mean, if the guy doesn't have the money, he doesn't have the money.
Okay, well.
Judge,
Let's just show the court that.
If I may, Judge.
You may.
I didn't see the need to file a motion for costs because you had already ordered the fee to be paid. I just wanted to enforce the order you already had in place. The only other alternative you would have is to somehow order Mr. Locking's client to pay the entire fee, which I didn't think you would do.
Right. No, I understand why you filed what you filed. And I see that I didn't make the appointment of the amicus. Judge Hepper did, but that being said, the amicus needs to get paid and is going to get paid, and we're going to figure out a way to do that. So, and there's a lot of creative things that I can do as a judge that the parties may not particularly like, but I'm going to get the lawyer paid. And Mr. Arrington is being very reasonable. I mean, $2,400 for an amicus. I mean, I do a lot of these cases. I haven't seen a retainer that low in quite some time. So it's not like it's a lawyer that's gone off the deep end and is, charging more than the lawyers that are handling the case. Sometimes we see that where an amicus comes in and, wants a $75,000, interim fee. And that happens occasionally, but that's not the situation we have here. So I don't want to spend a whole lot of time on this because, I mean, the court's gonna get the attorney's fees paid. I don't have the party here so that I can ask him questions and figure out what avenues I have available to make that happen. So it looks like all I would be able to do today, Mr. Arrington, is just reorder that fees get paid. And I don't know that that's going to do us any good since there was a previous court order by Judge Hepper several months ago telling them to get you paid. But
Judge, if I may, one thing that we could be open to is maybe reset this case several months down the road to allow Mr. Leggett time to make small payments. If he could make $200 payments like the assistant county attorney had suggested, had he made those starting back in February, it would have already been paid. And so if he started now and for 6 months or so, then that would get paid.
Yeah, that's one option. The other option is just, we set it for final trial, like 45. I think this has been set previously. But we set it for final trial 30 days out or 45 days out. But I don't know what, I don't know.
Well, I think we're
have
currently,
that
I think
may
we're currently set for trial next week, Judge. Sorry to interrupt you, but
Oh, okay. Yeah, I'm looking at,
Judge, may I
29th.
add a little input as well? Elton Lockings for Miss Baptiste.
yeah, so there was, I'm sorry, Mr. Lockings, the court was, let me clear one thing up with y'all first, because
Okay.
I had looked at this case yesterday, and I know Judge Heppard has heard most of the hearings on this, so I was just kind of refreshing my brain in case she sent y'all to me. But she set the trial for July 27th at 10 a.m. in a docket entry. But then I see that Mr. Burleson filed a notice of final trial setting, and it sets the trial for 7/29 at 10 a.m. So
that's
is
what
it
I
seven-
have is
is it 7/27 or 7/29? I needed to clear that up for the court.
I thought
got-
it was 7/29. I thought that's what she gave us at the hearing.
And it may be she just made an error when she made her docket entry. So all of y'all agree it's 7/29?
that's my understanding, Judge.
I'd have to look at my calendar, Judge. I don't have it in front of me, but it's one of those days are written down. Could you hand me my calendar? My briefcase?
Ms. Levert, so do you have your contest as well? Do you want, I guess, depending on, because I'm going to need the gentleman here for that affidavit of indigency, or affidavit of inability to pay. So what we can do is we can get a new date for us to come back to deal with that affidavit. But I'm kind of inclined that, I mean, he needs to make an effort. As long as he's making an effort, then, that establishes trust with the court, and Mr. Arrington's at least recognizing the person's taking the case seriously and making every effort he can to get some of the fees paid. So I'm going to reset the case and give him time to get the amicus paid. But on the other side, I've got Mr. Lockins' client that's probably itching to get this thing done. So Mr. Lockins, you wanted to say something, then I interrupted you.
Yes.
That court date. Go ahead, sir. You have the floor.
First of all, on the housekeeping, Judge, I have it in my calendar as the 27th. Secondly, I want to, I guess, piggyback on being present at the hearing as well as the arguments by counsel. Number one, the judge appointed Mr. Arrington and made the statement that she believed that he would be reasonable and work with us. I believe that is the proper language to use. I believe that is what he's done up to this point. I've talked with him about the case on several occasions, and he's been very forthright in meeting with the parties, meeting with the child, talking with the child psychologist and therapist, and all the things an amicus would do that would warrant him getting paid. I guess my problem with Mr. Leggett not taking his responsibility kind of goes along with some of the information from the county attorney, and that he filed the indigency affidavit. It's not necessarily complete. However, it does indicate that he has an income of $1,100. However, he does have information that indicates he could be working for a trucking company, which will be apparent in our hearing. However, he does seem to spend money on quite a few things that may not necessarily warrant necessity. If you put those things together and you say he's, according to the discovery responses, living with his parents, it would mean that he should have some disposable income. So notwithstanding us wanting to move this case, it also puts the amicus, notwithstanding what he decides to do, in an awkward position. If we're expediting going to trial on this case, he's still in a position of not getting paid. So we'd like to move it, but we'd like for everything to be done fair and give everybody an opportunity to do what they're going to do. He proved he's indigent. Mr. Arrington's proven that he's done the work. If we have to try it next week, we'll try it next week. But that still leaves him stuck out and having to do additional work to prepare for trial. So out of an abundance of professional courtesy, I'd ask the court to take all that into consideration on what you decide to do with our case today going forward.
Well, and I am going to reschedule Mr. Arrington's, it's his motion, and he's the one that's not getting paid. And I mean, it just doesn't make sense that someone would expect someone to work for free. It just doesn't make sense
Exactly.
to me.
Yes.
I don't understand that logic. And so he needs, and I understand if he's making $1,100 a month, it's not like he can just reach in his back pocket and pull out $1,200. The court gets that.
Judge, I'm sorry to interrupt you, but let me correct that. His total monthly expenses are $1,100 is what he represented on the statement of inability to pay.
Yes.
But he failed to put his monthly income.
Mhm.
He failed to
Correct.
include that or proof of that monthly income. And if I may, Judge, from what I see, he is a constituent of Florida.
That's correct.
He's from the state of Florida. And if I could, I think the legislative intent here for Rule 145 of the Texas Rules of Civil Procedure was to have this benefit set aside for Texans. I don't think they meant to open the floodgates for anyone just everywhere. So that is one thing that we would like the court to take into consideration. I know we are coming back for this, but that is one thing we would like the court to take into consideration.
I pulled up his affidavit and I see he says he's a driver for GGG,
Driver.
but
Yeah.
does not
Yes.
list any income, just left it blank. So that doesn't comply with what it needs to have. So he needs to at least amend that affidavit and put forth what his income is. But yeah, what I'm going to do is I'm going to reschedule the case, and I'm going to set it up far enough out that Mr. Leggett has time to pay Mr. Arrington. If for some reason Mr. Arrington's not getting paid, well, the court's going to release him. I don't, and I'm going to deal with his fees on the final trial in this case. But if the parties want an amicus on the case, they need to get him paid, and we'll just have to deal with that going forward. But
Incidentally, Judge, sorry to interrupt. I don't want to be released because I want Micah to have an extra voice in this case. But I understand your position that maybe if the parties can't afford it, maybe I should go.
yeah,
Well, if they can't afford it, he needs to show that he can't afford it. We need bank statements. We want to prove that he cannot afford it. So
Right, and
we
we're-
can move forward with that portion of the case.
I agree. That's kind of a last resort for the court, but I'm just letting the parties know I'm not going to be making an amicus sit through a trial
Absolutely.
when he's not getting paid. So
Yes.
Well, I would also like to add, Judge, that in front of everybody, I think it's admirable and commendable that Mr. Arrington is taking this child's well-being as a priority over getting the fees. And I'd ask the court to acknowledge that because we don't have these kind of amicus all the time. And for him to take that position over money, for me, it almost makes me emotional, as tough as I feel I am. So I'd ask the court to take that into consideration as well. And
No,
thank you, Mr. Arrington.
I appreciate you recognizing that, Mr. Lockins. I can tell you, I think the world of Mr. Arrington from the standpoint of he and I had cases against each other, complex property cases, and he was always a gentleman, always professional, but also a formidable opponent that was always prepared and did a good job in court. So y'all have got an excellent lawyer as an amicus, and someone that does care more about providing services than necessarily getting paid. But that's a great quality, and the court does recognize that. So we're
Thank you,
going to
Judge.
reset it to try to get Mr. Leggett some time to make the payments. Mr. Burleson, all I can tell you is that it goes a long way when there's an effort made. To just pay nothing is, you know, that's going to be frowned upon by any judge that I can think of. And so he just needs to be aware. He needs to be making an effort, or he needs to come in here and we need to have a hearing on his affidavit of indigency, and he needs to explain why he can't afford to pay $100 a month or something towards his child's lawyer. So we'll deal with that on another day. We're going to reschedule the trial date. Mr. Arlington, how far out did you want to move it?
Well, it kind of depends on how quickly Mr. Burleson thinks his client could make payments, but assuming he could make $200 monthly payments, then 6 months would get it paid.
Everybody's talking here without, I don't think he can make 200 a month. I mean, I got 1,500 from him for taking the case, and I didn't drop off because I believe that he has a right to see his child. That's the only reason I'm here. But if he had more money, I'd be getting more money. But
so was that not factored in when the appointment of the amicus was made? Did the judge not ask?
I didn't ask for an amicus. That was just, hey, you got an amicus.
Okay. All right.
The motion for the amicus, I think the amicus was appointed, Judge, as a consequence of me having the same concerns about the child's safety. I filed a motion to confer with the child. The child is not 12. The court heard some of our testimony and decided this child needed a voice.
Okay.
And that is why the judge intervened, in my opinion, and gave the case to Mr. Arlington.
Okay. All right. The court's going to reschedule the trial date for 6 months out. Let me look at my calendar. That's putting us in January-ish.
Correct.
All right, I have right now, it looks like, wait, hold on, give me 1 second. There is something that just came in where I'm gonna be out, and I don't want to set y'all just because that'll be tough on Judge Heppard if I'm out.
When you finish looking for that, I have a question, Judge.
Sure, I can do two things at once. What's your question?
Has this case gone to mediation? And if not, are you going to require that the case go to mediation before final trial?
It's been
Yeah,
mediated.
Has it been mediated since
Yes,
Mr.
sir.
Arlington has it been mediated since the amicus was on it?
I
No,
haven't.
sir.
I haven't been at a mediation, Judge.
No, sir, not since the amicus has been appointed on it. And I also had a question, Judge, and mine goes to notwithstanding the long reset to make sure Mr. Arlington gets paid. I would just like to have some idea for my client's sake, what potential remedies are going to remain in the event we go another month, 2 months, 3 months, and we're spending all this time and we're still not getting closure.
So what I would recommend is maybe the lawyers could file a status conference, and then the court will address the issues that are taking place at that time. So if for example, we reset this 6 months out and we get 2 months into the payment plan and there's been nothing paid, then somebody can file a status conference, and we'll
Thank you, Judge.
deal with the issue at that time. All right, I've got, looks like January fairly wide open, gentlemen. So if you've got your calendars in front of you, we can pick a date.
I'm pretty open in January, so if anybody
So am I.
wants to start picking, then
Is there a particular week that works best for y'all?
I'm
I'd say-
wide open, Judge.
I'd say let's avoid the very first week just in case there's any leftover holiday plans or anything like that. But then
Agreed.
Yes.
after the first week, then I think we should all be kind of itching to get back to business.
So I can do the week of the 10th or the week of the 24th.
Either's fine with me.
Either's fine with me.
Mr. Burrows?
That's fine. Whatever one, 10th or the 20th.
And are we expecting this to be a one-day trial?
I
2
think we
days?
can get it done shorter than that. I think
Yes, Judge.
Yeah, yes, Judge. I anticipate that we'll only have the two parties as witnesses plus Dr. Billingsley.
Okay. All right. So let's do, I can give y'all I can give you the 24th, 25th, 26th, or 27th.
What day of the week is the 25th?
25th is a Tuesday.
I'd say let's go for that.
All right.
I'm
125.
good.
Does that work for you?
25 works for me.
And Mr. Burleson?
January 25th, that's fine.
Would that be a 9 o'clock, Dr. Judge?
Yes, it'll be at 9 a.m. She previously set y'all at 10. But we're going to go ahead and do 9 a.m. because that way we can be exchanging exhibits and stuff and just things that might streamline the case. And then we'll just plan on, you're going to be starting around 10, but hopefully we'll be, if we haven't had little small things worked out before, then we'll deal with those between 9 o'clock and 10 o'clock.
And
All right, thank you.
Judge, I'd also ask as well, piggybacking on Mr. Arrington's earlier question, if the court is going to require another mediation prior to trial, I'm wondering if that would be another good option prior to a status conference, if the court would order us to mediate by a certain time, to at
Normally-
least get that out of the way.
Yeah, normally I do order a mediation after an amicus is on the case, just because I think that the dynamics of a mediation, when you got an amicus's view on there as well, when both parties know, you know, the amicus a lot of times carries a lot of weight with the court because they're an objective party. They're not a gladiator hired to maintain a certain position. They're looking for protecting the best interest of the child. So since everybody knows that, then they know when the mediator comes in at a mediation and starts expressing his or her views, that carries a lot of weight, and it may encourage the parties to reach some kind of agreement. That being said, I'm in a situation here that's unique because I have an individual that's not paying an amicus. And so now we're looking at, should I require more work on everybody's part and more fees potentially associated with the mediation? I can tell you that U of H Legal Clinic has a free mediation. And so I don't know where y'all mediated before, but they actually don't charge anything at all to do the mediation. So that's an option, that we could have a free mediation, but yet we still would be having the lawyer spend their time there. And then the other thing is always the DRC is an option, but I kind of like the U of H Legal Clinic. I try not to overuse them, but if I have a case where someone has filed an affidavit of inability to pay, I always consider U of H as an option for the mediation.
We did
what are-
previously use Miss Shelley Hudson, Judge, with
you're right.
DRC.
The other thing is, you know, the amicus can always use his or her influence by just talking directly to the parties. I just don't know if that's going to be something that will work in this case. I'm going to go to you first, Mr. Burleson. What's your attitude towards another mediation if it's free?
We can try it. I'm not very hopeful, but we can try it.
Mr. Lockings, your view?
Judge, my position is I don't mind at all. I would just rather we do it within 2 to 3 months if possible, instead of waiting 5.5 months
I
and then
absolutely
doing
agree
it.
with that.
So if we're gonna do it, I say let's do it. I like Ms. Hudson. I don't mind going to University of Houston, whatever's. We'll let the amicus be the tiebreaker on that, since Mr. Burleson is probably not opposed.
I would agree that I'd rather go to mediation sooner than later, because I actually believe that one of the elements that would be helpful in this case is if we could do something on a temporary basis before we get to the final trial, to kind of ease into what Mr. Burleson's client is going to want, if everyone can kind of read between the lines of where I'm headed there. But so I think a mediation earlier on would be helpful.
Yeah, it sounds like it would be, because the problem you have with going in on a final order is you tie everybody, you tie the judge's hands in some regards, because you don't have the option of maybe doing something creative and easing into a temporary order, which then would allow the judge to feel comfortable taking the step that maybe one party wants him to take. But so it sounds like it might be very beneficial for y'all to all get into mediation. And so we'll do that. We'll say that y'all need to mediate within the next 90 days. That'll be the deadline. You obviously can do it earlier than that, but you'll mediate within the next 90 days. If y'all can't agree on a mediator, then I'll appoint one. So y'all feel free to go back to Ms. Hudson if she's familiar with the case and everybody liked her. But if y'all want to go to U of H because Mr. Leggett can't afford Ms. Hudson's fees, then that's fine with the court as well. But I'm going to try to let y'all try to work that out, the logistics on setting the mediation. And if you need help, just come back and I'll appoint somebody.
Well, Judge, can we also, within the next maybe 60 days, in order to give Mr. Leggett some time to pay, if he can pay anything, can we give it about 60 days for the indigency claim so that we can get that settled before they go to mediation and take up any more of Mr. Arrington's time?
Yeah, I mean, right now the affidavit's insufficient on its face, and so the
Yes.
affidavit or inability to pay is denied at this point. But I'm not going to rule on that because it sounds like there was a notice issue, and Mr. Burleson just found out about it. So he may want to amend that pleading, and we'll come back and we'll deal with that on another day. But yeah, that's another thing that can be dealt with. Just send notice out and we'll take care of that matter whenever y'all are ready for it.
Do you mind telling me?
Excellent. Thank you, Judge.
I haven't looked at the affidavit in a month. Would you mind telling me where it's deficient or?
Well,
It doesn't say his income, just his expenses.
Right. It just there's a blank for what his income is monthly, and it's just nothing was filled in there at all. So.
And also he needs to show proof of that income.
Right.
Or lack thereof.
Or yes, or lack thereof.
Yeah, typically I want like 6 months of bank statements, a couple of years tax returns. If he's got pay stubs, I don't know, he may be an independent contractor with if he's a driver, but he should have 1099s, all that. So those are the kinds of things that I want when I have.
Well, I'm just relaying what he tells me. He's unemployed. He's not driving. That's what he tells me.
Well, they all say that. So.
And he did put it on there, Mr. Burleson. So out of an abundance of caution for you, can't tell you what to do, of course. If he put an employer on his affidavit, that on his face says he has a job with them to me. So he may be telling you one thing and writing something else, but we actually look at this stuff.
Well, he's paying the price if he is. I mean,
Well,
look at this.
Yeah.
I can tell you, I don't make decisions off whether or not someone's paying their bills or not. I mean, from a child standpoint, that doesn't factor into me at all. So just know that. But that being said, I didn't want to work for free, and unless I decided that. If I took a pro bono case, then I took that knowing I wasn't getting paid, and I didn't expect to get paid, and I treated that case just like the cases that paid me a whole lot of money. But that being said, I appointed this gentleman, and I expect him to get paid. I ordered that he be paid, or Judge Heppard ordered that he be paid. And probably the thing that irritates me the most as a judge is not obeying a court order and ignoring a court order. It's one thing if someone's making an effort. It's another thing when someone just says, I know what the judge said, but I'm not listening to the judge. That doesn't sit well with very many judges that I know. All right. Thank you, everyone, for appearing this morning. And,
Can I ask you one more question, Your Honor? You said 6 months bank statements. What else?
I normally want tax returns, 1099s, W-2s, all that stuff for the last 2 years. 6 months of bank statements for any account that he has. And then pay stubs for like the last 3 to 4 pay periods if he gets pay stubs. And then, he's the one that has the burden here. And so if he's got debt, he needs to provide me with statements for his credit cards or whatever he's got. All right, thank y'all.
Thank you,
Thank
Judge.
you.
Appreciate it.
Thank you
Okay,
very
thank you,
much.
Judge.
Anything
question,
else that
Judge.
anybody needs to address before we go?
Yes.
Oh, trial date. I gave you all the trial
You
date.
gave us a trial date, but at what point is the court going back to in person, or do you even know yet?
Well, we don't know yet. My guess is that that you're going to see us opening up. So we have a plan in place that covers the entire county, and that I think is going to get revamped September 1. So that will allow the courts a lot more flexibility in what they do. We're going to keep Zoom around for motions to substitute, motions to this little stuff, motions to mediate. It just seems like it's more efficient for the lawyers and for the parties to not have to drive down here, go through metal detectors or whatever, and sit around to have a 5-minute hearing when we could do it on Zoom. So more than likely,
Yeah.
we're going to have a Friday Zoom docket, or maybe a Thursday and Friday Zoom docket. And then but I'd like to see our final trials moving live, hopefully in the fall. Protective orders, motions for enforcement, those kinds of things moving live. But it's really Judge Hepard's call, and a lot of it depends on, if there's additional spikes and stuff, then it's just going to delay things. So we just it's not sure where we're going yet, but I'm hoping that September 1 is kind of a date to keep in the back of your minds where we may start opening up. Jury trials, what I've been doing on the jury trials is I'm setting those for status conferences in September. So unless I've got it's like a CPS termination where we have statutory deadlines that we need to get the trial started, the jury trials just aren't going anywhere, which is a mess, because anybody that wants to delay a case, and that happens, as y'all know, in some cases, files their jury demand, and now that takes the judge's power to move that case forward away. So hopefully we'll get back to normal soon so we can rein those kinds of cases in.
Okay.
All right. Thank you.
Thank you, Judge.
All
Have
right,
a great
thank
day.
you, Judge.
Thank you very much, Your Honor. Have a good day.
You're welcome.
Thank you.
Oh, we got our first 2022 setting, I think. It's crazy. All right, Ms. Haywood. Sorry,
Yes, Judge. How you doing?
I thought you were on that case. I made a mistake. I would have taken you at first over them because I knew that was probably going to take a while with all those lawyers.
It's okay.
On your case, Ms. Haywood, we were hoping he would show up because his waiver was signed the same date as the petition. So let me kind of break this down for you. So there's basically 3 steps to getting a divorce if somebody on the other side cooperates. So you have to file a petition, which is basically, hey, judge, I want a divorce, and here's my petition. You did that perfectly. That step, the first step you did, and there's no problems with it at all. The second step is your husband either needs to be served with some papers that say, sir, you've been sued for divorce, or he says, no, I don't need to be served. I'm going to waive that, and I'm going to sign this piece of paper that says I don't need to be served. So you had him sign that, which is good, and the form was good. It's just the law says he has to sign that at least one day after the petition is filed, and he actually signed it on the same day. So that
I talked to I mean, cut you off, but I talked to the judge, and she told me that last time, and I didn't realize that because I filed the petition, and I think when you guys, like when it was approved, I guess that's when I went and had that done. But I should have did it like just I should have just waited a grace period versus trying to, get everything done. So what I did was she told me to just have him re-sign them.
Yeah.
And I did that. And I sent in the final degree, the waiver, a new waiver, and it was another paper that she requested for me to fill out that was on you guys' website. The district
BVS
I sent in. Yes, I sent in all of that, and I realized yesterday, honestly, I realized yesterday that it wasn't on my case because I called in just to confirm the date and stuff. So she told me no, she didn't see it and stuff because I have the papers here and I have everything here, the new waiver and everything. And I called in just to confirm everything, and she said no, she don't see it on my case. And she said the best thing you can do is e-file it again. Make sure everything is correct. And she said, if you do it before, I called like at 9 o'clock in the morning. She said, if you do it before 3 o'clock, you guys will get it. So I was hoping that everything was in.
Okay,
If not, I can send you the information like through email or whatever, but I did e-file it again and I have the receipts. And this time it went to the right district.
Okay, let me look, because when I looked yesterday, I didn't see it. So maybe it's in there now, but let me take a glance. And then Jessica, if you can look in did you file it this morning or did you file it yesterday?
I did it yesterday before 3 o'clock. She told me to do it yesterday before 3 o'clock, and that way you guys get it.
Okay.
And I also have the receipts if you wanted to see that, but I did have him re-sign it. We got it notarized, and I sent in the final degree because he signed that too. And all the paperwork, I think the first time it went to another court or it got bounced back, but if I didn't never even call yesterday, I would never even know.
Oh, I see. So I see a decree that was filed today. A BVS form was filed today. I'm looking for let me look at your decree real quick. Your decree looks good. So, so you said he signed a waiver again?
Yeah, do you have the waiver?
Yeah, I don't see that yet. If I have that,
It was
it's
like,
gonna be ready to go.
it was the lead document, and now put 3 attachments.
Okay, it may be attached to something, and so it may be titled something differently. Let me look. You don't show it in e-filing? All right, Ms. Haywood, we see your decree, and that's good. So that's the third and final step, and that looks like it's done correctly. Both of y'all sign that. So all I'm missing is that waiver that you had him re-sign, and it's not showing up in my computer. So
That's so weird. I have it on my end that I sent it because I paid I think it was like $40 or something, $39 something.
yeah, you shouldn't have had to repay for that. I mean, maybe $2 or something. I know they do charge some nominal amount for filing something. I forget what that is, but like $2.08 or something.
It was that in the affidavit. She told me it was something on the website that I had to do.
Yeah.
And she said, just fill out the first part. I sent in all of those information. Is there any way that I could send it to you today, like right now, like an email or something, and still, because I do have it.
Yeah, let me, I guess let me see what you've got. So why don't you email that? I'm going to put in, do you have, are you on your phone?
Yes, I can get a tablet though.
Well, it's okay. You don't need the tablet. I was just going to put the email address in the chat box, but it might be easier for me to just tell you and you can write it.
Okay.
Because on your phone, I don't know, I don't ever use my phone to do Zoom, or I haven't. So I don't know if you can see what I put in the chat box or not. So the email address to mail that waiver
Mm-hmm.
would be 387.
Mm-hmm.
And then the word exhibits, EXHIB as in boy, ITS. So 387 exhibits, and then the @ sign, Fort spelled out FORT, Bend, BEND, County, tx.gov, GOV. If you want to repeat that back to me, make sure we got it right, then you can email that.
Okay, I got 387 387 EXHIBITS at FORTBENDCOUNTYTX.gov.
You got it. That's exactly right. So if you want to email that waiver there, then
I
I'll
can
take
do
a look
it.
at it. I
It
may
is
be able
on
to.
my phone. I can do it probably as I
Okay.
talk to you because I have all the documents. I'm so sorry about that. I have no
No,
clue why
there's,
you didn't
look,
get it.
you're doing stuff that even lawyers mess up. So it's hard to do. The court totally understands that there's problems sometimes with filing things. So just take your time. We're going to hopefully get you done today.
Thank you. I appreciate it. I just didn't want to wait another 30 days. EX. Three, 8, 7. EXHIBITS at FORTBENDCOUNTYTX.gov. Okay, I sent it over to you.
Sometimes it takes a few minutes to come through because we have like this filtering program, but I should get it here any second. It's there, maybe that, there it is. Good thing. All right, waiver. Yeah, that looks good. So.
Yeah, with the new date.
Yes, ma'am.
Okay.
I don't think I can print it to your printer because IT never set this up. So I'll just print it to the copier room. All right, ma'am, why don't I do this? I've got to go get it. I'm going to go run, get that real quick. It'll just take me like a minute or so because it's the printer in the courtroom doesn't work, and I'll be right back. Okay.
Okay, no problem.
My bailiff's going to get it for me. So just, we'll be done in just a few minutes.
Okay. Thank you. I appreciate it. Thank you so much.
You're welcome. So you're originally from Michigan?
Yes, sir.
How long have you been in
Originally,
Texas?
I only been in Texas since 2018. I came really right before Harvey.
Oh, no.
I-
You came,
yeah, that's how. Yeah, Texas welcomed me with Harvey.
that didn't scare you off. Nothing will. Yeah, you don't sound like you're from up from Michigan. I wouldn't have placed you from Michigan, but
Yeah, well, I always used to come in Houston when I was little, so that's why I wanted to move to Houston. But I lived in actually I went to school in Akron, Ohio.
okay.
That's all. I'm originally from Michigan, but I went to school in Akron, Ohio for 4 years, and then I moved to Houston. So I'm a traveler.
Judge Hepard's from that part of the town. She's from Ohio, and
Oh, okay.
that's where she was raised. All right, we're going to go ahead and file that, and then Miss Haywood, if you would please raise your right hand to be sworn.
Mhm.
Do you solemnly swear or affirm the testimony that you're going to give in this cause will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes.
All right, if you want to read that, you can put your hand down. If you want to read that sample testimony that you have there, that'll be most of the information that I need in order to grant the divorce. And then if I have any questions, I'll follow up with those.
Okay. You said sample testimony.
Yeah, that thing that you filed, that you emailed me, I think the second page, it says sample testimony. So it'll
Oh
say
yeah.
like,
Okay.
yeah, if you can read that one.
Go back to my email. I'm getting to it. I'm sorry.
But you know, I can just ask you the questions if that's easier. We can do
Yes.
that. Why don't we do that? So if you can get your video back up and running. Okay, are you presently married to Dennis Haywood?
Yes, sir.
And prior to filing this petition for divorce, did you live in Texas for the 6 months prior to filing this?
Yes.
And did you live in Fort Bend County for the 90 days before you filed the divorce?
Yes, sir.
Has your marriage to Mr. Haywood become so bad the two of you can't live together as husband and wife?
Yes, sir.
Is there a reasonable chance the two of you can go back living together as husband and wife if I refuse to grant the divorce?
No.
Were there any children born or adopted during the marriage?
No.
And are you presently expecting a child?
No, sir.
And have you reached an agreement with Mr. Haywood that divides up the property that you have and any debt that you have?
Yes.
And do you feel that agreement's fair to both you and your husband?
Yes, he signed what he was willing to pay on the final degree, and I signed what I was willing to pay on the final degree. We both came to a mutual decision.
Okay, and you think that's fair?
Yes, sir.
And then you're also asking that your name be changed to Kawana Lascelles, and then is it Bornds?
Yes, go back to my maiden name. Yes,
And how do you pronounce that? Borns?
Borns.
Okay, and it's Bornds?
Yes, sir.
Okay. And are you doing that to try to avoid the police or to try to avoid creditors?
No, sir.
All right, Ms. Borns, the court has heard your testimony, and I am approving all the agreements that you've reached with Mr. Haywood. I'm granting your divorce. I'm also granting your request to go back to your maiden name, and I've signed your final decree of divorce. You're going to want to get a copy of this order because it officially changes your name so that you can change it with driver's license, DPS, Social Security, wherever you need to change it. And you can get that order from the district clerk's office. Okay?
Okay.
Thank you, Ms.
Okay.
Haywood, and good luck to you.
Okay. I did have a question. I just go in and ask for a copy, or do I pay a service online, or?
Yeah, they can request it online, right? Or on the phone? Okay. Yeah. So there's two ways to get it. You can go to the district clerk's website and they have a copy request form, and you can put your case number and tell them you need the final decree signed by Judge Bell. It's 8 pages, so they will charge you $8 for that order,
Mhm.
and it'll have the seal and it'll have my signature on it and everything. Or if you want, you can come to the district clerk's office physically. And you come up here, you go to the 3rd floor to the district clerk's office here at the courthouse, and you can just tell them that you want a certified copy of your final decree of divorce, and they can give one to you there. And again, I think it's $1 a page. But you do want to make sure you take your case number with you, because if they have to look up your case number, I think there's a charge for looking up your case. So just make sure you bring that case at 21 DCV 279756. And those are the 2 ways to get the order.
Okay. Thank you.
All right. Thank you. Have a great day.
Thank you. Bye.
She's a nice lady. Looked like she was a teacher. Looked like she was in the classroom. I wonder how long Mr. Leggett would work for free. If he was here, that's what I would have asked him. People. All right, that's done. So let me check in with Judge Shepard, see where she is.